Third-party rights. Section Objectives. 1. Define assignment and delegation. 2. Recall the rights and duties of an assignor. 3. Recall the rights and duties of an assignee. 4. Understand the rights and duties of a delegator. 5. Understand the rights and duties of a delegatee. 6. Describe the characteristics of a third-party beneficiary contract. And finally, 7. Differentiate between a donee beneficiary, a creditor beneficiary, and an incidental beneficiary. Now, one of the things that we all realize is that as a general rule, the only parties that have rights under a contract are the parties that are privy to the contract. Privy simply means these are the parties that actually entered into the agreement. However, situations do arise where rights are assigned and duties are delegated. Now, before we begin, we have to go over some definitions, right? This will make this stuff crystal clear for you. Assignor. An assignor is an original party that receives rights under a contract. Assignee. An assignee is a new party to whom rights under a contract are transferred. Obligor. An obligor is the party with the duty to perform under a contract. Obligee. An obligee is the party that receives the performance. Now, to make this really simple, focus on the base words. Assign, obligation, right? It'll make it really clear for you. Now, both the assignor and the assignee are the obligee. The assignor is the original obligee, and the assignee is the new obligee. Now, once again, that's the person that's receiving the performance. Delegator. A delegator is an original party with a duty to perform under a contract. Delegatee. A delegatee is a new party to whom the duty to perform under contract is transferred. Both the delegator and the delegatee are the obligor. The delegator is the original obligor, and the delegatee is the new obligor. Now, once again, focus on the base words. Delegate is where delegator and delegatee comes from. Obligation is where obligor and obligee come from. Now we're going to start off with assignments. An assignment is the transfer of contract rights to a third party. Probably the most common contract right that's assigned is the right to receive money. Here's our example. David owes Lewis $1,000, and Lewis owes Maria $1,000. Lewis assigns his right to receive $1,000 from David to Maria. Lewis is the assignor. Maria is the assignee. David is the obligor, the party with the duty to perform. Lewis is the original obligee, the party receiving the performance, or in this case, the $1,000 from David. And Maria is the new obligee, right? That's the person to whom Lewis transferred his right to receive money from David. Now, real important point here. When contract rights are assigned unconditionally, the rights of the assignor are extinguished. And equally important, the assignee has the right to demand performance from the obligor. Now, what this means for us is the assignee now has the right to sue to enforce the contract. Now, the assignee takes only the rights that the assigner originally had, and these rights are subject to the defenses that the obligor had against the assignor. So right away, something you should understand is you cannot assign rights you do not have. I'm going to say this one more time. You cannot assign rights you do not have. Right? For those of us who live in New York City, if we're renting our apartments, in the absence of the lease stating otherwise, you have the right to sublet your apartment. Now, when you sublet apartment, what right are you assigning? You're assigning the right to rent the apartment from you. You're not assigning ownership of the apartment. Why? Because you don't own it. Now, in this same situation, whatever actions your landlord can bring against you to evict you from the apartment, the subletter would also be subject to. Now, as we said, as a general rule, all rights can be assigned, but there's some rights that cannot be assigned. So we're going to go over those now. A right cannot be assigned if a statute expressly prohibits it. All right, so this means that it's against the law. All right, for example, I could not assign my right to conceal carry my pistol to you. Why? The law prohibits such an assignment. You have to have your own license to carry your own pistol. A right under contract cannot be assigned if the contract is uniquely personal. Now, I want you to focus on that word uniquely, right? A uniquely personal contract is something that's more or less one of a kind. It's something that's designed for a specific person, right? Easy example of this would be massage therapy. You're in an accident, your back is injured. The doctor looks at you and thinks that the best treatment for you would be massage therapy, right? So he or she writes a prescription for you to receive this massage therapy. Now, when you go to the therapist, right, you go with your medical records, with your prescription. The therapist reviews your records, examines you, and comes up with a specific treatment plan for you to address whatever issues you have with your back. Now, this contract between you and the massage therapist would be uniquely personal. You could not transfer your right to receive a massage, let's say to your little brother who fell down the steps and hurt his back. Why? Because his injury is not your injury, and the treatment would likely be different. Now, I want you to focus on uniquely, uniquely, uniquely. If something is standard, even if the contract is to you, you could transfer that right. Right? An example of that might be you are having your apartment painted, you figured out the colors, the schemes, right? Whatever details you wanted. Your younger sister lives in the same building that you live in. In fact, they live in the same apartment line. You live on the 20th floor, they live on the 15th floor. You live in 20B, they live in 15B. The exact same apartment. Room layout is exactly the same. Even though you contracted with the painter to paint your apartment in the colors that you wanted, you could transfer your rights to your sister to have her apartment painted in those colors, right? Why? It's not uniquely personal. It is personal, but not uniquely personal, created only for you in a way that applies only to you. 3, a right cannot be assigned if it would materially increase or alter the risk to the obligor. Now, once again, just in case you forgot, The obligor is the party with the duty to perform. And one of the things that contracts try and do is make everything fair for both parties. Now, this particular limitation applies primarily to a needs-based contract. A needs-based contract is a contract where one party agrees to supply another party of all it needs of a particular item for a specified period of time. Now, by way of an example, let's assume I am a bicycle manufacturer and you produce bicycle tires. So I come to you and I say, I would like to purchase tires from you for 1 year. I'd like you to supply me with all of the tires I need for a 12-month period. Now, some questions that you might have would be, well, how many tires do you require? And I would come back and I would say, well, it varies. It depends. Some months we're very busy. Other months are slow, right? On a busy month, we might produce 400 bikes. And on a slow month, we might only produce 200 bikes. So you think about that and you say, okay, we can do this. Because what do you know from that? You don't want to average how many tires you would have to produce for me, right? Busy month, 400 bikes, 800 tires. Slow month, 200 bikes, 400 tires. What's the difference between 8 and 4? Nice middle ground. 600 tires on average is what you would have to produce. You know that you could produce that many tires comfortably and take on other contracts to maximize your production capabilities and therefore your profits. Now, after we entered this agreement, I could not assign my right to receive all of the tires that I need from you to a third party. Why? Well, the third party I assign my rights to might be the Walmart of bicycle production, and they make 6,000 bikes a month every single month. Now, you know you can make 600 tires. Can you make 12,000 tires a month? No, that would materially increase or alter your risk, because if you can't meet their requirements, they could sue you for breach of contract. Now, conversely, I could not assign my rights to receive tires to a custom bicycle manufacturer who makes one, at most 2 bikes a month. Because either you're selling them 2 tires or 4 tires, and what would that do? It would impact adversely on your bottom line. Wouldn't be fair to you. Now, please bear in mind, if I had a contract from you that specified I was to receive an exact number of tires, let's say 700 tires a month, I could assign that to a third party. Why? 700 tires to me or 700 tires to another party, the risk is exactly the same for you. There is no change. Now, number 4, this is my favorite. Ordinarily, a right cannot be assigned if the contract stipulates that it cannot. Right? So basically, what this is saying is if the contract says you can't assign a right, you cannot assign a right. Now, the reason why this is my favorite is because with this exception, there are some exceptions. Specifically, the right to receive money can always be assigned whether or not the contract prohibits it. An assignment of rights in real estate can always be assigned whether or not the contract prohibits it. Now, there are some exceptions to this exception that deal with property law, but what we're talking about right now are general rules. Number 3, the right to a negotiable instrument, these are stocks and bonds, can always be assigned whether or not the contract prohibits it. And finally, an assignment of the right to receive damages for a breach of contract lawsuit can always be assigned whether or not the contract prohibits it. Now, to be clear, the reason for this exception to the exception deals with a term called alienability. Now, alienability means you have the right to alienate, separate something from yourself, right? And if you owe something, you can do whatever you want with it. So if I said, I'm going to pay you $1 million, but you can't spend it, you can't give it away, you can't use it, is it your money? If I entered into a contract to sell you a house, but I said, but you can't sell it, you can't let anybody live in it, you can't rent it out, is it your house? Now, negotiable instruments, stocks and bonds, if I give you stock and I say you can't give it away, you can't sell it, you can't transfer it to another party, is it your stock or are you just holding my stock? And then finally, the right to receive damages. Damages are really just money, so the first rule applies. If it's your money, you do what you want with it, right? If you can't use your stuff, it's not your stuff. It's not your stuff, right? So these are exceptions to the exception. Now, since I did mention that when it comes to real estate, property law does control, there are some limitations, right? For example, if you have a specific use clause in a gift or a sale, that specific use would apply, right? If you say, I will give you 500 acres for so long as you use it for XYZ purpose, it belongs to that person and they can use it however they see fit as long as they're using it for the stated purpose. Real big example that I have for this would be Camp Alpine, which was some campgrounds in northern New Jersey, about 15 minutes from Manhattan, that industrialists in the latter part of the 19th century donated to the Boy Scouts. It's about 500 acres of pristine land and one of the most valuable real estate sites in New Jersey. Now, the Boy Scouts are allowed to let anybody who wants to camp in that. They can let the Girl Scouts use it, they can let citizens use it, but they cannot sell it. They cannot develop it for anything other than scouting. Why? Because the title to the land states that if they use it for anything other than scouting, it would revert back to the descendants, the heirs of the grantors, the people that gave them the land, right? So with real estate, there are some limitations. Now, as I mentioned before, all right, when I talked about subletting an apartment, in the absence of the lease stating that you cannot sublet, you can sublet. However, if the lease says you can't, you can't, right? So those are some exceptions that are specific, right, to real estate. Notice of the assignment. An assignment is effective immediately, whether or not notice has been given to the obligor. Now that's important. It's effective as soon as it's made. Until the obligor has notice, the obligor can discharge his or her obligation by performance to the assignor. It is the duty of the assignor to forward payment to the proper part, to the assignee. Let's talk about loans, student loans in particular. Most people take out a student loan from a bank. Now, banks are in the business of making money. They're not in the business, generally speaking, of administering student loans. Right? So the bank makes you a loan so you can go to school. The bank administers the loan for about 2 years, and then the bank sells the loan to a loan servicing company. Right? Basically, they're cashing out. They're getting some money so they can move on. Now, you don't know anything about this assignment, so what do? You honor the contract that you have with the bank, and you keep on making your payments to the bank. Now, because the bank knows about the contract that it has with that loan servicing company, it's the bank's duty to forward the payment to the loan servicing company, right? Because you don't know anything about it, so the bank has the responsibility of forwarding that loan. Now, once the obligor has notice, only performance to the assignee can discharge the obligation. If the obligor fails to tender performance to the proper party, the obligor runs the risk of performing twice. All right, let's continue with our student loan scenario. The bank has assigned their right to receive your payments for the student loan they granted you to a loan servicing company. The bank and the loan servicing company send you notice that the loan has been transferred, and the bank and the student loan company direct you to make payments to the student loan servicing company. Now you say, I did not enter into a contract with them, I'm not paying them. But you're an honest person, so you keep on making your payments to the bank. Now, because you have notice of who you were supposed to pay, that loan servicing company can sue you for breach of contract. Now, in a perfect world, the bank would do the right thing and forward payment to the loan servicing company, but they are not required to do so. Why? Because you know to whom your duty is owed. You know to whom your performance is owed. Now, why do you run the risk of performing twice? Well, because that assignee will sue you for breach of contract. They have the right to receive the money, so the court will grant a judgment in their favor. Now, yes, you can turn around and sue the bank to get your money back. But in the meantime, you performed twice because you did not do what the law required you to do and perform to the proper party. Now we move on to the second part, very, very similar, delegations. A party can transfer duties under a contract through delegation. No special form is required to create a valid delegation of duties. As long as the delegator expresses a present intention to make the delegation is effective. Now, delegations occur a lot. Right? One of the most common forms of delegation would be contractors subcontracting the construction of a house. Right? You hire what we call a general contractor to build a house for you. Right? And basically what this person is the supervisor for the project. Right? They don't do all the plumbing, they don't do all the carpentry, they don't do all the masonry themselves. What they do is they delegate those duties to third parties. Now, one of the things that is really important about delegation is the consent of the obligee, the party to whom the performance is due, is not required for delegation. I'm going to say this one more time. The consent of the obligee, the party to whom performance is due, is not required for delegation. Now, just like with the assignment of rights, there are some duties that cannot be delegated. Delegation is prohibited when performance depends on the personal skills or talents of the obligor. You have hired me to paint your portrait. I am a professional portrait painter. You picked me because you like my technique, the way I use shadows and color. Now, there are other professional portrait painters, but they paint differently than me. You picked me because of my personal skills or talents, and because of this, I could not delegate my duty to a third party. Delegation is prohibited when a special trust has been placed in the obligor. Now, when we say a special trust, I like to think of things in terms of business. So a fiduciary responsibility, right? The responsibility that somebody has a skill set that will help your business. And I like to think about a board of directors, right? You pick people because you know them, you trust their judgment. So if I'm on your board of directors, I could not delegate my duties towards your company to my secretary. Why? You don't know my secretary. You didn't pick my secretary. You picked me. You trust me, a special trust, so I could not do that. Another way of looking at this would be if you have kids or when you have kids, there might come a time when you need some free time. You and your significant other might want to go out somewhere, have a nice date, and you need somebody to watch your kids. So what do? You go through resumes, you interview the perfect au pair. And you pick the person that you're going to trust your pride and joy, your babies to. That person, let's say her name is Mary Sue, and she's an 18-year-old college student who was a member of the Girl Scouts. She has training as an EMT. She is the perfect person and has been working as a babysitter for 3 years. And you've got all these references. Mary Sue could not delegate her duties to watch your children to her little brother Timmy, who's 13 years old and incorrigible, and all he cares about is video games. Why? You don't trust Timmy. That's why you didn't pick him. So she could not do it. Delegation is prohibited when performance by a third party will vary materially from that expected by the obligee. Now, I want you to underline in your notes, very materially. That means significantly. You have hired me, a master carpenter, in fact, more than that, an artisan, to create a one-of-a-kind dining room set for you. Now, I'm known as the tree whisperer. I go to the forest and I look at trees and I select the perfect trees for my pieces, and then when I start to create them, I let the trees talk to me. The way the grain goes and the color of the wood, to construct unique, one-of-a-kind, museum-quality pieces. Now for this, I charge a pretty penny because I'm really, really good and I'm worth it. So this dining room set might put you back $35,000. Now, I could not delegate my duty to design and construct your dining room set to my assistant, even if he was another master carpenter. Why? Because what he would do would vary materially. It would be very, very different, significantly so, from what I would create for you. Now, if you're one of those people, and we all know them, who like to name drop, so you hire me because I'm famous, not to design a special set of furniture for you, but to hang standard kitchen cabinets from Home Depot in your kitchen just so you can say I could do it. In that case, I could delegate my duty to my assistant. Why? Whether I hang the cabinets or he hangs the cabinets, it will be essentially the same. It will not vary materially from what is expected, unlike something that is custom made by me for you. And finally, delegation is prohibited when the contract expressly prohibits delegation. Now, unlike with an assignment, there is no exception. If the contract says you cannot delegate a duty, you cannot delegate a duty. And once again, this is because delegation does not require the consent of the obligee. Right? You can just do it because you want to. Right? However, once again, if it's written in the contract that you can't, you can't. Now, what is the effect of delegation? Normally, if the delegatee, the party to whom the duty to perform was transferred, fails to perform, the delegator is still liable to the obligee. Now, if you think about this, it makes sense. Who are the parties that are privy to the contract? Who are the parties that entered into the agreement? It's going to be the delegator and the obligee. The delegatee is not privy to the contract, so who maintains responsibility? The delegator, the delegator, the delegator. Now, an exception occurs if the delegatee has promised performance that will directly benefit the obligee. Now, if this occurs, there's an assumption of duty, and a breach of which makes the delegatee liable to the obligee. Now, that's a mouthful, so let me explain it with an example. I'm a general contractor, and you've hired me to build a house for you. Let's say it's a 3-bedroom ranch-style home. in the master bedroom suite, right, we came up with a plan for a bathroom, right? And this is the plan you and I, your general contractor, have agreed on. When the plumbing subcontractor comes in, you enter into an agreement with him or her that substantially changes the agreement that you and I had. And this plumbing contractor promises to do all these things in a contract between you and him or her. Because this is above and beyond the contract that you entered into with me, I, your general contractor, would not be liable if the plumbing subcontractor makes mistakes. So you couldn't sue me, you'd have to sue him. Why? Because you entered into a separate contract distinct from the one you had with me with that third party. Now we move on and we talk about third-party beneficiaries. When a promisee intends at the time of contracting that performance benefit a third person, the third person becomes a beneficiary of the contract and as a result has legal rights. This means if the promisor fails to keep the promise that benefits the third party can normally bring an action against the promisor to enforce the contract. Now we have a few types of beneficiaries. Number one is an intended beneficiary. An intended beneficiary is a third party for whose benefit the contract was entered into. I hire you, a landscape architect, to cut my mother's grass. The purpose of the contract was to cut my mother's grass. My mother is an intended beneficiary. Number two, incidental beneficiaries. An incidental beneficiary is a third party who benefits from a contract by chance. Let's say, God forbid, you get arrested. You have my card in your wallet. I'm the only lawyer that you can think of. So you call me to represent you at your arraignment. Now, in order to get to the courthouse, I have to take a cab because there's no parking. I'm not driving. In the contract between you and I, the cab driver that picks me up is an incidental beneficiary. The cab driver was in the right place at the right time, and because of that, the cab driver benefited from our contract, right, by way of earning that fare to the courthouse. Now, when you called me up to represent you, when we entered into a contractual relationship, you were not thinking about that cab driver at all. So the cab driver was incidental, not intended. Now, this is important. Why? Because only intended beneficiaries have legal rights. Third parties who benefit from a contract only incidentally have no legal rights under the contract. Now, rights are not automatic. Rights must vest before an intended beneficiary can enforce the contract. So the question is, when do the rights of an intended beneficiary vest? Until the rights of an intended beneficiary vest, he or she cannot enforce the contract against the original parties. The rights vest when the original parties cannot rescind or change the contract without the third party's consent. This occurs when the beneficiary, 1, manifests assent to the contract at the request of the promisor or the promisee. I have hired you to cut my mother's grass. My mother is an intended beneficiary. You say, have your mother call me and let me know when she wants me to cut her grass. So I tell my mother, and she calls you up and she said, I'd like you to come and cut the grass on Friday. When she calls you up and says, I'd like you to come and cut the grass on Friday, my mother, the intended beneficiary, has manifest her assent to the contract as per the request of the promisor. Her rights have now vested. She now has the right to enforce the contract. Rights vest when the beneficiary materially alters his or her position in detrimental reliance on the contract. I have hired you to cut my mother's grass. My mother had a young man named Davy who would cut her grass every Wednesday. When she found out that I hired you to cut her grass, she fired Davy, relying on you to cut her grass because of the contract I have with you. Now, she relied on our contract to her detriment. She had help, now she doesn't. Her rights have now vested. Her rights have now vested. She can sue to enforce the contract. A beneficiary's rights vest when conditions for vesting mature. You are a driving instructor, and I've hired you to give my daughter driving lessons beginning on her 17th birthday. My daughter is now 16. Well, let's make her 16 years, 11 months, and 2 weeks old. So you got 2 weeks. On my daughter's 17th birthday, the conditions for vesting mature. She now has a right to sue you to enforce the contract if you don't do what you promised to do. Now, if a contract expressly reserves to the contracting party the right to cancel, rescind, or modify the contract, the rights of the beneficiary are subject to those changes. Now, the key here is expressly. What does expressly mean? It means you actually put it in writing. It's specifically in the terms of the contract. It is not implied. It is stated. Incidental beneficiaries, this is really easy. An incidental beneficiary cannot enforce a contract to which he or she is not a party because the benefit that he or she receives from the contract is unintentional. Right place, right time. We were not thinking about this person at all when we entered into the contract. So we talk about intended versus incidental beneficiaries. Very easy once again. In the presence of one or more of the following factors strongly indicate that a third party is intended as opposed to incidental. 1, if performance is rendered directly to the third party, they're intended. 2, the third party has rights to control the details of performance. Let's go back to my mother. What detail did she control? Right, when the person was going to cut the grass, and presumably how the grass was to be cut. Or 3, there's an express designation, right? If you mention a third party by name or class, my mother, Janice Claire, that's name. My children, that's a class. They are intended beneficiaries. That's how you tell the difference, right? If these things don't occur, generally they're going to be incidental, and that means generally they have no rights. And that concludes our discussion on third-party rights.